So good morning, everybody, to the third in the series of Altamimi's Construction Infrastructure Hidden Risks in GCC Contracts. As you can see, I'm accompanied today by my colleague Ewan Lloyd, who is from our Abu Dhabi office. Myself, Andrew Sims, I'm usually based in Qatar, but today we're both in our brand new Altamimi premises in the DIFC in Dubai. The offer is there to any of you who are based in the UAE to come and visit us whenever you may wish. And similarly, if any of you who aren't based in the UAE would be interested in meeting us either in Qatar or any one of our other offices around the region. So, as you'll have seen, the topic today, two topics, termination and damages. And I just wanted to take you through the slides to illustrate the topics that we're going to deal with and how we're going to deal with them today. So, the format for today is, if you can put the slides up for us. So, in relation to the 45 minutes or so that we're going to have today, the purpose and approach as previously is really just to give you an overall introduction to some of the issues that we're encountering, Ewan and myself, on GCC construction contracts, and really to try and compare and contrast certain legal systems with the GCC, particularly common law legal system. And then Ewan will take you through some issues in respect of termination and issues off the back of that, and then me with damages and limitations in relation to construction contracts, and then finally a question and answer session. So if we move through to the next slides. So there we have it. Ewan's element, termination, so in respect of the contract and the general law, and then me with damages, recovery, limitations, contractual, and the general law with the questions and answer session. We've said 45 minutes, a little bit of flexibility in that, just depending upon how many questions we may get towards the end, and then we'll just do a little bit of an advert for the next session at the end. Okay, so next through to the next slide, and I hand over to Ewan.
Okay, thank you very much, Andrew, and thank you very much, everybody, for dialing in today. As Andrew says, my part of the webinar is about termination, and I'll probably spend about 20-22 minutes going through termination from a fairly kind of practical perspective. And I think a couple of kind of points from the outset I'd like to make. First of all, termination is a fairly complicated topic, and so time available, I will be scratching the surface and giving some high-level pointers. And then the other kind of comment I'd like to make is kind of a health warning, if you like, because people do talk about terminating contracts. When it comes down to it, termination is a very adversarial position to take, and if you do terminate a contract, it's likely there will be some repercussions. Difficult to say what kind of form these consequences may take, but you could find yourself in litigation, which could be fairly expensive and drawn out. And so I've got a few comments to make about potential workaround solutions that people can look at as opposed to actually terminating contracts. So I'll come to these shortly. But first off, like I say, this section is about termination. So, I think any kind of starting point is to look at the bases upon which you can terminate a contract, and fundamentally there are two. The first basis is at law, and the second basis is under the contract. And so, turning first of all to termination at law. Well, typically that will arise if a contract doesn't actually deal with the party's rights to terminate. And so in that situation, a party seeking to terminate has to look at the potential rights you can invoke under local law to end the contract. And so, you know, the situation does vary from jurisdiction to jurisdiction. But across the GCC, there are some various parallels, I think you could say. But taking the UAE as an example, under the UAE Civil Code, there's a particular section which deals with works contracts. And in that section of the Civil Code, it sets out three bases upon which a construction contract can be terminated. And these are upon completion of the works, cancellation of the contract or termination of the contract with the consent of the parties or by court order. And I think the first two grounds are probably pretty self-explanatory. The final ground by court order needs a little bit of explanation maybe, and how that may work in practice if one party believes the other party has failed to perform, wishes to terminate the contract, and therefore that party makes an application to the court to actually issue an order to validate the contract termination. And in that situation, the court will look at the judge will look at the overall circumstances and decide if termination is the appropriate outcome in that situation. But I suppose there's one thing to notice. There is a tendency or a leaning towards preserving contracts. And so as opposed to ordering a termination, a court may actually order specific performance. So there's no guarantee that a court would actually order a contract to be terminated if there is a possibility for the contract to be kept alive. And so for that reason, it's common for parties to prescribe the grounds for termination under their contract. So next slide, please. And so this next slide I've got, it basically discusses typical contractual grounds for termination. And like I say, I think it's in everybody's interest that the contract is clear, all the risks and entitlements and so on are clearly spelled out, so there's certainty. This also accords with the underlying principle that freedom of contract applies in the UAE and also across the other jurisdictions of the GCC. And so, I've listed out some typical grounds upon which construction contracts can be terminated. Most of these are fairly self-explanatory, but I'll just kind of run through them quickly now. So the first is, from a contractor perspective, if you're not being paid, the employer's failing in his fundamental obligation, and so that typically gives rise to an entitlement to terminate. And also, if works aren't being certified, or applications aren't being certified, it can also trigger an entitlement to terminate as well. Conversely, I suppose the contractor's key obligation is actually to undertake and complete the work. So if he abandons a project, then that will typically activate a ground for termination. A couple of other fairly common grounds to terminate are failures to provide performance security or failure by the contractor to comply with insurance obligations, also assignment or subcontracting without consent, or other very typical grounds for termination. But these, I suppose in my experience at least, although you do see these grounds for termination under contracts, these tend not to be the primary grounds for contracts to be terminated, and more kind of add-ons or ancillary grounds to terminate a contract. I'll say a bit more about this in the next slide. Insolvency as well is of course very, very relevant and very common sense, but then of course it's important to look at the drafting of the contract and to see how insolvency is defined, if at all, because if insolvency is not defined, there could be all sorts of issues as to what actually constitutes insolvency. I think two of the major grounds upon which termination is often affected is down to performance and delay. That goes back to the old kind of concept that the key issues in any construction contract are cost on one side, but also quality and time. So in terms of performance, that kind of goes to quality, and it can be a little bit of a subjective, as to quality and performance. And so typically a party will only terminate in respect of performance issues if there's a an objective basis to do so. And by that, what I mean is if there are tests on completion which haven't been passed. So if you've got like an output-based facility, i.e. a power station, and the output requirements aren't satisfied, and the tests on completion haven't been satisfied, and that could trigger a ground to terminate. And similarly with delay as well, typically, contracts in this part of the world say that, the contractor is liable to pay delay damages up to a cap of 10%. And if the cap of 10% is exhausted and the right to terminate is crystallised, that also kind of feeds in with the whole issue of performance, because, for example, the works that satisfy the performance criteria, you then can't actually complete, so that kind of feeds in with the delay issue as well. So these are kind of fairly kind of standard grounds to terminate for breach. A couple of other grounds I just want to kind of touch on. The first I've mentioned is prolonged force majeure. And I've mentioned this particularly because it's very topical right now in the context of this COVID-19 environment in which we all live. But I think in many ways this is a little bit of a red herring, because typically force majeure is premised on the concept of impossibility of performance over a prolonged period of time. And impossibility is a pretty difficult threshold to satisfy. There usually are some workaround solutions that parties can deploy. And so, look, I mean, in terms of termination of force majeure, in my experience at least, I've only come across it in the context of civil war and insurrection. That's a different story, but it doesn't really, it's a fairly, in my view, it's got a fairly narrow ambit in reality. The other ground for termination, something to touch on quickly, is that of termination for convenience. And that's a typical ground for termination. It's required to give flexibility, because of course, circumstances do change, and employers may need to reevaluate their investments and their portfolios and so on. And so that flexibility is required. But termination for convenience it tends to be negotiated quite closely. There's a couple of key issues to look out for. First of all, if you are the employer, you have got a ground to terminate for convenience in your contract, it's important to just double check if there are any kind of consequences or any restrictions around that entitlement. So maybe a restriction which says, okay, you can terminate for convenience, but you then can't award these works to a third party. And conversely, if you are a contractor or a service provider, and your contract has got termination for convenience in it, it's important to carefully check the entitlements that accrue upon termination, because typically you would be entitled to be paid for the works or services that you have performed, but it could be various kind of add-ons which also need to be compensated, such as breakage costs and amortized costs, for example. So you want to make sure that you will be kind of made whole, you won't suffer any out-of-pocket losses on account of such a termination. So moving forward onto the next slide. And so, okay, so you've got a contract, you've got clearly defined grounds for termination, which is great. But that's only part of the story. The next part of the story is actually to look at the reality of the situation, look at the actual facts. And so, have the facts as they have arisen, do they actually justify or correspond with the grounds to terminate? And if you're the party looking to terminate the contract, you've got the evidential burden to establish that these grounds to terminate have crystallised. So it's really very important that the grounds upon which you want to terminate are interrogated to make sure that they are correct and that a breach has actually accrued. And so, for example, just a very quick example, if you want to terminate for delay, and the cap on delay damages has been accrued, it's very important to double check that the contract hasn't got some extension of time which may negate entitlement to terminate. And as a kind of belt and braces approach, if you like, we always recommend that if you want to terminate a contract, it's always advisable to terminate for more than one ground, because if one ground turns out to be invalid, you can then fall back on another ground to terminate. And then the other thing to look at is procedure, because typically a construction contract or a services contract will map out the procedure that has to be adhered to in order for the termination to take place. And so there'll be notice periods, for example, cure periods. And so it's very important that if you are terminating a contract, you actually strictly follow these procedures, because if you don't, the other party could turn around and say, well, actually, you didn't adhere to the, you give us a cure period, you could have cured that breach, hence your termination is wrongful. And just as an add-on, I'll come back to this concept of good faith, and good faith, acting good faith is an extremely important concept in the laws across the GCC. So I think it's important that if you are terminating a contract, it's necessary to demonstrate that it's not opportunistic. You have got valid grounds upon which to terminate, and these grounds have been validly substantiated. Next slide, please. And so, I've discussed, basic contractual grounds to terminate, the procedures to go through, and then that's only kind of very much part of the story. The next part of the story is to look at the consequences and the key issues to consider arising out of any termination, because I think in some ways, actually terminating the contract is the easy part. What comes next can be fairly complicated and can be laden with risk. And so I've set out some bullet points of key issues to look at. And so I think the first point to flag is, if you're going to terminate a contract, make sure you terminate with clean hands. What I mean by clean hands is that if you're, for example, the employer terminating the contract, you've ensured that you've complied with your obligations, and so there's no basis upon which the contractor can come back and say, well, okay, I didn't perform, but the reason why I didn't perform was because you failed to pay me, that kind of thing. And if you kind of get into these kind of arguments, it'd be quite easy for the contractor to then kind of allege that the termination is invalid and therefore wrongful. And so, so I think it's very important that all certified payments have been made prior to a contract being terminated. And then an add-on point to note as well is, if you do terminate, if you're an employer and you do terminate a contract, and there are outstanding payments due to the contractor, there's a chance that the contractor may seek to retain possession of the site until its entitlements have been discharged. And that can cause a lot of kind of complication. It's a very kind of complicated issue, which could be a topic for another webinar. Moving down the list, I've said it's important to delay damages and also to liquidate performance security. And I say that because there's an argument that delay damages and also performance security are ancillary obligations or requirements, if you like. And so if the primary obligation, i.e. the main construction contract, is terminated, there's an argument that the ancillary obligations also fall away. So your right to delay damages will fall away, as will your right to liquidate the performance security. Now, there are various kind of counter arguments which can be raised, but that's something just to bear in mind. It's also very important that the status of the works is clearly recorded upon termination. And I say that for two reasons. First of all, it's necessary so that a final account can be worked out upon termination. And also, if the matter were to go to dispute resolution, such records are valuable. But then, look, I think probably one of the key points is this point about strategy. And I think the message is to always kind of look before you jump. And so I put down some key issues to look at before a party should terminate a contract. That's to make sure that once you do terminate a contract, you can then kind of invoke or step into the next contractual relationship to complete the works in a relatively painless fashion. And so, just quickly, I've said it's important to determine the cost to complete, and by that I mean, you can work out what's the outstanding value of the works to actually complete the project, and then allied to that is the importance of actually working out how you have enough security to cover that. So if you liquidate the performance bond, keep the retention, you may have 20%, 25% of the contract price. Is that enough to actually complete the works? Then you've also got to look at the mechanism or the procurement approach that you'll deploy to complete the works, and that can be fairly difficult. And different approaches can be looked at. You may wish to engage various subcontractors directly to complete the works, or you may want to appoint a new main contractor. But either way, in my experience, at least, if a contract has been terminated, replacement contractors consider have got enhanced bargaining power. They're likely to charge a premium to step in to complete an unfinished project on account of the risk profile, and also you're likely to lack or lose any kind of single point responsibility as well, which can be invaluable. A couple of other issues just to look at as well is making sure you've got all the designs you need to complete the work, all the other deliverables, for example, such as O&M manuals if they're relevant. And just quickly on design deliverables, I was involved in a matter a few years ago, and the employer terminated the contract, rightly so as well. It was a proper termination, but when he actually came to looking to complete the works, he realised that he didn't actually have any license or any right to use the underlying design documents. That caused all sorts of issues. And so connected with this point about strategizing the approach to complete the works is also the need to anticipate how the other side may react. And so I think it's important to kind of place yourself in the shoes of the party has been, put yourself in the shoes of the party has been terminated, and try to preempt and work out how you may respond. And so there may be various kind of spoiling tactics you may deploy. And also the other thing as well, which I touched on, is to look at is to be always kind of conscious that formal dispute resolution may be on the agenda if a contract is terminated. Just conscious of the time, just kind of moving on to the next slide. This is quickly about alternatives to termination, because termination, like I say, is a fairly it's very adversarial step, and so are there any kind of workaround solutions you can look at? And so possibly there are. If you are a contractor, if you are an employer and you're looking to terminate a contract, or I think it's necessary to look at the reasons for the contractor's non-performance. If you actually identify the reasons for non-performance, it may be possible to look at ways to actually address this. And so in the current kind of market, liquidity could be a problem. And so if liquidity is a problem, maybe it could be a case for making a cash injection, for example. There could be a case for realigning the payment milestones so they're more front-loaded. These kind of commercial outcomes or solutions which should be clearly documented. Another issue is de-scoping. You can take works out of the contractor's hands, but in my view, that only really works if the contractor is amenable to this approach. Because if it's not amenable, there'll be all sorts of issues in terms of integration. And from a contractor service provider perspective, if you're not being paid, for example, what can you do? You want to kind of basically fire a shot across the bows of the employer to look at maybe decelerating performance, or maybe suspending or withholding performance. Ideally, you'd have the right of the contract to do so, but you haven't got the right of the contract. There is typically assistance available under local law, such as the Article 247 of the UAE Civil Code. But just on that point, it's very important to act fairly and proportionately in these situations. And just moving on to my final slide. These are the key kind of takeaway points I just want to underline. And so just running through these points quickly. Like I say, termination is the option of last resort. So, always look at alternatives, see if they can work around solutions. But ultimately, sometimes termination is necessary. In that situation, you've really got to be very diligent in your adherence to the contract. It's vital to ensure that the factual circumstances support the basis for termination. Always keep records. You can then substantiate your position subsequently. Always strategize, work out the next steps, and look before you jump. And I think the final kind of catch-all thing I'd say is always kind of act in good faith. And that concludes my quick run-through of termination points to note. A lot of things to.
I know we've had a couple of questions that have come in,
Right.
so we'll leave those until the end.
Yeah, sure.
Right, so moving on to the second session. Mine is in respect of damages, and just to give you a brief outline of the structure of it, I was going to touch first of all on some of the concepts in respect of damages, then specifically from a common law perspective, because that I think ties in with the next stage, which is just to look at one particular clause from the FIDIC contract, the FIDIC Red Book, to see the terminology that's used within that, and how it is that it's linked with common law expressions of damages, and then to draw it together to then review the relevant legal provisions from both the UAE and Qatar to see where you might be making certain assumptions about what it is that you may or may not be able to claim, and how it is that a FIDIC contract, for example, relates perhaps slightly inconsistently in some respects with the way in which the GCC law works. So go to the first slide, please. So what I just set out there is really this whole idea of whichever jurisdiction you're in, whatever the legal system, there's going to be a concept of contractual damages. There will be the general law relating to the recovery of damages, and then there are going to be the clauses within the contract, whether those are, or terms of the contract, whether those are express or implied, and then obviously limitations or restrictions. And again, these are going to be either through the general law or through the contract itself. As I say, by way of introduction to the theme, I just wanted to set out that within the FIDIC suite of documents, the remedies are very much from a common law perspective. One thing that I want to emphasise, and I come across it time and time again on a daily basis, is the use of the word indemnity, which in English law has a very specific meaning, and it's rather lost when it moves into other jurisdictions. As I say there, the question of an indemnity or the consequences of an indemnity in English law is that the damages that can be recoverable for an indemnity obligation are rather more extensive. In practice, it might not mean that it's necessarily quite a significant difference, but there is definitely the possibility, depending upon what sort of loss has been suffered. The next point I wanted to make, and I make this as sort of an Australian lawyer, pointing the finger at my British colleagues, is the distinction between what are costs and losses. So both of those fall under the head of damages. But they are two quite distinct things. In a lot of the English cases, the distinction isn't really drawn. And it is quite important, I think, when you're thinking about what it is that you're going to be able to claim, what it is that you are paying out over and above what you would have been paying out, that's a cost. And a loss is where there has been a loss of an opportunity in some way, or loss of profit. Unfortunately, in English law, and indeed in the English language, the term losses is used interchangeably, when actually in law it should mean something quite distinct. Then I touch on liquidated damages, which in English law just recently has been going through a whole sort of revolution, only very recently to come back to what was the position that everybody thought it was, relating to liquidated damages in the context of termination. And then finally, and it's one of my favourite clauses in the Red Book, which possibly says how sad I am as having been involved in the law for so long, clause 17.6, which is a very interesting clause in terms of what it introduces and the dangers well, first of all, understanding it properly in the context of your law, and secondly, any tinkering with it, amending of it, which may have quite inadvertent consequences for either the employer or the contractor, depending upon the situation that arises. So we go to the next slide. So I make no apology for doing a little bit of a quick run through the contractual law as it is applied in the common law jurisdictions, particularly in England. You can see that there is a great case there, and if you ever want to remember a case and you're in construction law, remember Hadley and Baxendale. It's from a very, very long time ago, but it's still good law, and it establishes the nature of the damages, and there are these two limbs. But my second bullet point there is just making the point that actually it doesn't, the Hadley and Baxendale test, which everybody rolls out, doesn't really deal with other questions which people start to get confused about, which is direct and indirect and consequential. The two limbs in Hadley and Baxendale are those damages arising in the usual course of things, and then the second one is in the contemplation of the parties when they made the contract. So it's a sort of things which are aware between the parties. A great example of that are the two cases, McCain and then Hotel Services. I always like the Hilton one, which relates to the minibars in hotels, which didn't work. Consequently, there was a massive loss of profit, as any of us know who stay in hotels, a massive markup on what you get out of your minibar. The contractor thought that he was safe because he'd got a clause which referred to indirect or consequential loss. And the court turned around and said, no, that is definitely one which was in the reasonable contemplation of the parties at the time when they entered into a contract for minibar fridges in a hotel, therefore provides absolutely no protection for the contractor whatsoever. Then liquidated damages, the case that I was referring to as being the sort of somersault followed by a return to normal is this case called Triple Point, which is all in respect of liquidated damages as they accrue during the course of the contract. But then when there is a termination, and it links to some of the points that Ewan was making, when there is a termination, what is the status then of the liquidated damages provision? And is there an entitlement to claim general damages? Obviously, we could go into great detail in respect of what liquidated damages are and how they're supposed to operate, but just take that as a key point in terms of English law related to liquidated damages. And then obviously there's another aspect of liquidated damages, which is not just delay, but relates to performance, particularly, again, as you would say, in respect of process, energy and manufacturing contracts, where there's a pre-agreed sum for a failure for a piece of kit not to do what it's supposed to do. And then finally, irrecoverable damages, and this is always a classic case of the guy, Mr. Forsyth, who had a swimming pool built. It wasn't quite to specification, and he wanted the damages for reinstating the swimming pool when everybody knew that there was absolutely no way that he was going to build a new swimming pool. He was just going to pocket the damages that were going to be awarded. And the court turned around and said, no, you can't have those damages. Okay, so that's certainly any questions in relation to common law position on damages. I'm happy to answer. So go to the next slide, please. And so, as I say, my favourite clause, 17.6 of the FIDIC contract. Now, I've highlighted some of the words in bold there just to try and illustrate some of the quirky bits that there are within it. But as you can see, it's a clause which is a limitation of liability clause. Neither party, so it's for the benefit of both parties. Not all limitation of liability clauses are always expressed as being for the benefit of both parties. So that's definitely something worth checking. Then it deals with a concept of what we would possibly call indirect or consequential losses, but it specifically lists out three types of loss. Loss of any use of the works, loss of profit, loss of any contract. And then it tries to use this sort of generic wording of indirect or consequential. But as I've said, using that sort of wording might not actually really achieve what you want to achieve. So it's very important that you list out the specific types of damages which you do not want to be liable for. The next point that I've highlighted is in connection with the contract, and that is a thing which is specific perhaps to common law jurisdictions, which is where what the draftsman is trying to do is also limit liability insofar as it might be claimed under tort for negligence or one of the tortious heads of damage. Causes of action. That has a link in with the GCC perspective, but certainly that is what is intended. I haven't highlighted it, but I did then identify two exceptions to that cap. The two there that I've identified link very much with Ewan's talk and also what I've just been saying about indemnities. So those limits on liability in a standard FIDIC contract will not apply if your contract is terminated. Or rather, sorry, if the contractor terminates. So that is subclause 16.4, which is all related to the contractor's termination. So if a contractor terminates, then he is potentially going to be able to claim all of his loss of use, loss of profit, and loss of any contract. In relation to indemnities, that is an exception. Now, normally, the FIDIC wording is fairly standard, the indemnities are limited to certain things, usually third-party rights or intellectual property issues. But there is often, because people don't necessarily understand what indemnity is supposed to mean, there is tinkering with the FIDIC indemnities. And quite often you will get an additional indemnity added, which includes breach of contract by the contractor, which immediately means that this limitation on liability has no benefit to the contractor whatsoever. So this interplay between amendments that are being made in the body of the contract and your limitation of liability clause is absolutely key. And then just to move very quickly off this slide, the next paragraph is in relation to a cap, financial cap, very, very standard. But again, you can see that there's a whole series of exceptions to the cap, the financial cap set up. And then finally, the whole of the clause won't apply in the context of fraud, deliberate default or reckless misconduct by the defaulting party. And the short point is that in relation to the common law, that needs to be in there because it doesn't necessarily apply if that clause is not included. Okay, you can move to the next slide forward, please. So, quite a busy slide in many ways. I won't spend a huge amount of time going through it, but essentially, in both the UAE and in Qatar, it is very clear from those articles there, Article 292 in the UAE and 263 in Qatar, that the concept of damages, although the word used is loss, will include a broad range of damages, including loss of profit. But in both jurisdictions, and it's similar in the other GCC jurisdictions, that there is something of a similarity with what I've just been describing in respect of common law, particularly the first limb of what was the Hadley-Baxendale damages test. So in the UAE, the natural result of the harmful act, or the natural consequence of the breach under Article 263 in Qatar. So irrespective of what you might have put in your contract, the GCC civil codes give an express entitlement to a very broad range of damages. And it will be a case of proving what is damage that is a natural consequence or natural result of the harmful act. I've included under the heading rectification of defective works, which is to deal with that swimming pool example of Mr. Forsyth. And it's interesting that in both the UAE and in Qatar, there is the statutory civil code ability of the courts to step in, never mind from a contractual law basis, common law precedent basis, to step in and say that actually a demand by a party for damages which are over and above what is proportionate to the rectification cost is there. So as you can see, Article 106 of the UAE Civil Code, the interests are disproportionate to the harm that will be suffered by others. And similarly, Article 63, 3 of the Qatar Civil Code relating to the employer abusing its right if there is this disproportion. Move to the next slide, please. Really, this is more just to make a statement that actually in both jurisdictions the concept of indirect or consequential losses is not one which is recognised. It's in a contractual context. It is allowed in the UAE in respect of a tortious claim, but not in contract. And then in Qatar, indirect or consequential losses are not recoverable under Qatari law. So to a certain extent, the additional wording that is relied on very often in the FIDIC 17.6 is not really relevant because the liability doesn't arise in the first place. But perhaps what it re-emphasises is that what you really need to be doing is focusing on the express words about what, if you are going to limit the damage, what is it that you really do want, or you are prepared to forego, or as a contractor, what is it that you are prepared to pay? The second point in relation to limits on liability is very straightforward. I mean, it all goes back to the bargain between the parties being the law between the parties in all the GCC codes, which is insofar as you have identified a limit of liability in your contract, then you will be bound by that, save where there are certain express provisions within the civil code of a mandatory nature. And for example, in Qatar, Article 259 identifies that fraud or gross negligence are circumstances in which a limit of or exclusion of liability would not be effective. The final point that I've just got there on in relation to Qatar goes back to that point that I was making in respect of clause 17.6 of FIDIC, where the limitation clause is supposed to apply in respect of the contract and anything arising under the contract, which is trying to cover the tortious recovery, such as negligence. In Qatar, it's actually prohibited to exclude tortious or limit tortious liability. So, next slide, please. And this is the final one in relation to just having a look at some of the provisions for damages in the UAE and Qatar. It's a source of some surprise to many common law lawyers coming into the GCC that in fact what on the face of it appears to be a completely compliant liquidated damages figure is capable of being reviewed. I mean, from a common law perspective, the ability of the courts to investigate, interrogate the figure behind a liquidated damages sum, to some extent, defeats something of the purpose of having a liquidated damages figure, which is always going to be a trade-off of some sort between both employer and contractor. But nevertheless, there is this principle in all of the GCC civil codes in respect of the ability to overturn the liquidated damages figure. But it is interesting to just distinguish between the different jurisdictions. So within the UAE, there is certainly an argument to be run that the interrogation of the liquidated damages figure could be such as to either reduce it in order to, insofar as the employer's damages were lower than the liquidated damages figure, and there is an argument that in fact it might be increased. Now, this because the employer's liquidated damages have been greater. Sorry, the actual damages have been greater, but it hasn't really been tested. In Qatar, the question is there's no doubt that it can be revised down. So, then yeah, I just wanted to link that then with with the clause 8.7 of the FIDIC. In its unamended form, what it says is that the liquidated damages are to be the exclusive remedy, and that's wholly for delay, and that's wholly consistent with certainly a common law interpretation. Yet FIDIC, interestingly, then adds a few extra words, which says, except in a case of termination by the employer. So, back to some of those thoughts that Ewan was expressing relating to the dangers of termination or for a contractor, that potentially, if there is a termination, a valid termination by an employer, the apparent protection of the liquidated damages figure may be removed completely so that there is an exposure to general damages. But then there is another important aspect from the employer's side, and that is, and Ewan's already addressed it, and it is get your liquidated damages claim in, coupled with whatever you might be able to do in relation to your bonds, before you terminate. An interesting interplay again. And obviously, I'm using the FIDIC 17.6 and clause 8.7 as a sort of benchmark, but it really does mean you need to read your own contracts for the purposes of establishing properly what your terms and conditions do actually say. Okay, good. We go to. Oh, we seem to have missed a final slide, which is slightly disappointing, but maybe bringing us to the question and answer session slightly further. I mean, I had it looks like we've lost a slide, but there's a summary at the end, which if anybody does want these slides, we're more than happy to circulate them, where really what I'm saying is that the overall position is that irrespective of what law applies to your contract, there are similar features. However, it is absolutely essential that you do read your clauses, firstly, to understand, number one, this concept of indemnity and how that plays into damages. Secondly, indirect and consequential losses. What is it that you're actually excluding? Thirdly, in relation to termination, how might some of the protections that are built into your contract during the course of performance suddenly disappear when there is a step of termination? So, on that basis, then maybe we switch so that it's to you and myself in person as opposed to slides. And I'm just going to we're just about on time. I think we've just got a room for a couple of questions, maybe. Bear with me while I just try and get these up. So if my contract is wrongfully terminated, I suppose this links across both of us, doesn't it? If my contract is wrongfully terminated, what compensation entitlements do I have? I mean, do you want to do that first of all?
Yeah, sure. So I think the first thing is to, like I say, you're going to terminate a contract, make sure you do it properly in accordance with the contractual procedures, make sure that the actual facts kind of, fit the grounds upon which you're going to terminate. But fundamentally, wrongful termination is a breach of contract, gives rise to a damages claim, and of course, a lot depends on the governing law, but we're looking at the UAE or GCC perspective, you'll typically be able to recover your direct and your direct losses arising out of that breach. And then there's all those mechanisms that I'm describing, where potentially it's you've got to get over the hurdle of showing that you're in the right, as opposed to the person who's trying to terminate you, and then establishing what your entitlements are on the basis that you've terminated. I mean, maybe that linked in with what I was talking about. So on the liquidated damages clause in the FIDIC contract 8.7, if there's a termination by the employer, then that
means that the liquidated damages figure no longer applies, or liquidated damages provision is no longer the only remedy. In relation to the 17.6, in the case where it's the contractor that's terminated, then the limitation on liability doesn't apply. So in a scenario where, let's say the employer is wrongfully terminated, he's then going to be trying to claim that extensive additional delay damages. From the contractor's point of view, he's then going to say, no, actually, I'm entitled to my loss of profit, and 17.6 as an example doesn't apply.
Yeah, I think so. I think the other point as well is it's in terms of losses and damages, you know, they can't be too speculative. They've got to be a clear causal link.
Yeah.
And also the party who alleges has to prove as well. You've got a burden of proof to actually establish what your losses are.
I think then there's another question here, which is again, it's yours rather than mine. Is and this is something that we do see time and time again, where people have played around with the contract. I'll give you the scenario, and then ask the question of Ewan. Quite often, when it's the employer that's drafting a contract, or for using a standard form contract, there will be a termination clause which allows for termination by the employer, termination by the contractor, or termination where, for example, a force majeure, and it's neither one party's fault nor the other. Now, very often I find that overly enthusiastic employers' lawyers will delete the contractor's entitlement to terminate. Now, sometimes there may be a very good reason to do that, but actually, in my view, it's usually an error, because just because you've deleted a clause doesn't mean to say that there isn't any underlying ability to terminate. So I think this is the question that's been asked. It's what if? So what are the consequences of termination of a contract without adhering to the termination procedure? So, well, it's two things there, isn't it? What if there isn't a termination procedure, and then if you followed a procedure and you've got the wrong procedure?
So I think I agree with Andrew. There's no kind of right to terminate under a contract. I think it's a bit of an own goal as far as the employer is concerned, because you'd be deemed to be acting oppressively and maybe contrary to good faith. And in that situation, if you are a contractor, you haven't been paid for months, whatever, you go to the court and say to the court, well, this is the situation. I've got no right to terminate under the contract. Can you please give me an order to terminate? In that situation, it is totality as well, given the overall kind of conduct of the parties. I think it'd be a fair point, a fair chance we would get termination, or the judge would at least order specific performance and order the employer to make payments. I think that's the answer there. What was the second point, sorry, Andrew?
It was insofar as the procedure hasn't been followed properly.
Yeah, so
related to the same.
I mean, it kind of goes back to the other point that the contract is king. If you're going to terminate a contract, you've got to make sure you do it with kind of clean hands, if you like. And by clean hands, you've got to ensure that you've got a basis to do so, and then actually strictly follow the procedure to give the appropriate notices. Give cure periods, and if the contractor on the other side has actually corrected that breach within the cure periods, then that breach goes away. So you can't be seen to be acting oppressively, because if you do act oppressively and terminate a contract, that's contrary to good faith. That could come back and bite you.
Yeah, I was just going to add one point that's come up very recently with us, and it relates to the FIDIC Clause 17.6. Ewan's just reminded me, talking about an employer's failure to pay. If you remember, the final paragraph of Clause 17.6 says that all of the protections and limitations in 17.6 will not apply in certain cases, one of which is fraud, obviously. But there is then an interesting concept, deliberate default. Now, that begs in the context of a failure to pay, is a failure to pay, which the contractor then uses as a basis for termination, a deliberate default, which removes from the employer the protection of clause 17.6. But this goes back to all of these issues. Well, it's both in relation to what I've been talking about and what you've been talking about, which is actually steps relating to termination, whether it's the contractor or it's the employer, really need to be thought through very carefully. Firstly, in order to avoid a subsequent argument that you are in fact in breach, and secondly, in order that you, from a legal point of view, understand what the damages consequences are, both in terms of what you're able to recover or what it is that you might be exposed to. And then finally, the more sort of practical issues relating to how do you get the job finished?
I think just on the payment points as well, I guess there's a bit of a distinction because, if the payment's not been certified by the employer, there's always a bit of room to argue. But if the payment has been certified under the contract, very difficult not to pay that amount. Yeah. And that could link in with what you're saying, Andrew, about the default.
Yeah.
Okay,
well, I think we're pretty much up on time. Certainly, just to conclude then, obviously this was the third in this series. We're intending to run another one sometime in October. Some of you may be aware that Ewan has also been running a series in respect of Saudi Arabia in particular, with a focus on issues arising out of Saudi contracts. There's likely to be one of those at the end of September. And then in terms of topics, well, we've got our own ideas. Certainly, if anybody has certain pressing issues that they would like us to deal with, please let us know. And I hope you've found today informative, and look forward to speaking to you next time. Thank you very much.
Thank you.